Right. Now, the faction of the Rivers State House of Assembly, loyal to Governor Siminalayi Fubara, has invited a senior advocate of Nigeria, Dagogo Iboroma, for screening and possible confirmation as a member of the State's Executive Council. The House, in a statement issued in Port Harcourt on Sunday night by its clerk, Dr. G.M. Gillis-Harry, directed the senior lawyer to appear before the legislators this Monday, May 13, 2024, at the Admin Block, Government House, Port Harcourt. Correspondents learned that if confirmed, Dagogo Iboroma's son will be sworn in as the new Attorney General and Commissioner for Justice of Rivers State. Recall that the office became vacant about 2 weeks ago following the redeployment of the former occupant, Professor Zacchaeus Adango, to another ministry by Governor Fubara. Adango, however, resigned. Now, let me start with you, Henry.
Yes, please.
What is your take on the current Okojombo faction swearing in a commissioner in Rivers State? Is that acceptable?
Thank you. I am not a media practitioner, and I wouldn't fall in the trap of the media, where I would also call out the media that will have to report following actual legal positions. See, it doesn't matter what institution or authority or agency or group or individual in this country. We have a ground norm, the Constitution of the Federal Republic of Nigeria. So I think we should get to the point where the media should report the Rivers State House of Assembly with respect. We have just one Rivers State House of Assembly. The Constitution of the Federal Republic of Nigeria, 1999, Section 90, creates just one House of Assembly for each of the 36 states. You can't have different. You can't have factions. You could have people who probably will impersonate, who will arrogate unto themselves, as I am now. Can I wake up one day and say, I am a member of the Rivers State House of Assembly, or I am the Speaker of the Rivers State House of Assembly? Then the media will now say, a new faction has emerged. One barrister, Henry Ekine, says he's a speaker. That will not be helping our society. But having said that, the Rivers State House of Assembly exists and will never cease to exist. And there would always be members, except until God forbids that every one of them dies. So at the moment, we had circumstances that led to seizure of certain persons as members. Number one is death. Where we have a 32 seats Rivers State House of Assembly, one died. That's a natural factor that we could lose a person in the legislature. And then it became 31. And then when it became 31, at some point, 27 of them publicly, on their own will, without any prompting, took out a decision, which they have an absolute right to do. So they ceased to be members of the political party that sponsored them into that house. And knowing the consequence of that will simply mean they will vacate their seat, especially where a speaker makes that proclamation. And that has happened in Rivers State since in December 2023. So those 27 ceased to be. So together it would mean that they had all also left. So we had a few of them, about 4 or so that were left. Then sometime again, about 31st or so of December, one of them resigned. It's one of the ways in the Constitution that you would cease to be a member. When you resign your membership of a house, you cease to be.
You mean the other faction?
There is no faction. I wouldn't fall into that at all to mention a faction. I'm talking about the Rivers State House of Assembly. I considered all of them as one.
Right.
If you heard me, I talked about the late person, Ameule and his friend. They were all members of the Rivers State Assembly.
How you have laid it down accurately.
So I'm getting to the point now.
Accurately.
Yes.
Before you get to the point.
Yes.
Now, let's still dwell a bit on the 27 defected lawmakers and the other 4. So, was there at any point a court order recognizing both of them, recognizing Martin Amehule as the speaker and also recognizing Edison Ehe as the speaker?
Beautiful question. But let me say first, I'm a lawyer, right? And these matters are sub judice, some of which I know very deeply. So I wouldn't comment into the merit or otherwise of those matters in court. But I will speak to the Constitution as a constitutional scholar and as someone who advises the largest human rights organization in this country with respect to the provision of the Constitution, upholding the rule of law, which is the cardinal core objective of the CDHR. Okay. Now, the Constitution of the Federal Republic of Nigeria is clear. It doesn't require an order of court. This is the problem we have in this country, please. Section 109, subsection 1, paragraph G, does not require any involvement of judiciary.
It doesn't?
It doesn't. It is here to be read out.
So is it a self-executing?
It's self-executing.
No.
No.
Are you aware there is a proviso?
I am a lawyer and I read it,
right.
and I claim to be a constitutional lawyer. The constitution is here to be read out.
Right.
If they read it and they refer to a law, to a court, I won't mind even throw my wig away. The constitution is here. So let me say what I mean. Now, I mean that there is a section of the constitution that is extant. And you know what? It is important for those who are watching to understand that we had a situation of a mischief. There was a time in this country that you wake up in the morning, you defect from one political party to another. You wake up in the afternoon, you defect from one political party to another, the same person, and there was no consequence. That is in law called a situation of mischief. It was the entire country, the National Assembly, that saw that this wasn't deepening democracy. It was not strengthening democracy. So we needed to put a stop to that. And to put a stop to that, we altered our constitution to the effect that, look, you no longer move anyway, anyhow you like. If you dare move, that you lose your seat. The constitution is shall vacate. And every lawyer knows what it means, shall vacate. Then the thing there, who was to act, not a court, they said the speaker shall declare those seats vacant and do what? And communicate INEC to conduct election to fill those vacant positions. That's all.
All right.
It's no requirement of the court.
All right.
Rather, the
now,
proviso.
If the defectors
Yes, please.
give a reason for their defection.
Good.
Based on
I'm going to the proviso. Excellent. Do you know where they were to give their
reason? Is it
reason?
not left for the court to now determine?
No way.
I'm asking a question.
Go on.
Is it not left the court to determine whether the reasons given by the defectors align with the proviso in the constitution or not?
You know what? This is not the first time it has happened. You know who was to go to court? Not the Rivers House of Assembly, not the speaker. Listen. Now, what ideally is not the first time, and I will tell you where it has happened, and it has got to the Supreme Court who went to court. Now, when this situation of defection happens, the purport of the Constitution, the drafters of the Constitution, not the politicians today, the purport, the intendment of the drafters of the Constitution, you lose it automatically. The speaker makes that declaration. Then when the speaker makes that declaration, INEC conducts election. That is the ideal situation that Nigeria wanted. Now, what happens is, when you so defect, whatever reason you have is to your heart. Then when the speaker so declares, if you think you have any justification to that declaration, you go to court to say the declaration of the speaker.
After you have vacated your seat?
Of course.
Really?
Yes, that's the situation. It happened in Ifedayo. It was Ifedayo that went to court.
Well, how come INEC in this case has not done the need?
I am not in INEC. I have held INEC accountable to that. Do you know what? There has been an action for INEC to mandate to conduct the election. I didn't want to go deep into this anyway, but since you're raising it,
yes,
please do.
Can I ask you a question?
Yes.
Now, when elections are conducted,
yes.
Let's start with Governor Siminalayi Fubara. Governor Siminalayi Fubara, after he emerged as the Rivers State governor, you know, there were concerns and there were agitations by other political parties questioning his emergence, and they went to court. And while they were in court, he was sworn in, correct? And he was acting as a governor pending the determination of the court. So why is that case different with the legislatures, who actually the Constitution has given a proviso?
Go on.
That only a judiciary.
The Constitution didn't say so. Please don't. No, that's not the position.
Hold on. What is the job of the judiciary?
It is not in this. I was telling you.
So
you know where the judiciary will come in.
Constitutions that the judiciary has no business.
Look at. I've told you where they are to come in, but you are missing it. Okay, with respect to you, look at where they are to come in. They are not to come in to declare the seat vacant. They have no role. Okay. The Constitution said the person to declare the seat vacant. My colleague is here. And the Constitution is here. It's the speaker.
Okay, now
hold on.
Are you also aware that the speaker at that time, that is Edison here, was suspended prior to that time?
I don't want to go deep into that. I'm not mentioning names.
It was his emergence as a speaker legal. Do you build legality?
No, hold on.
Prior to, don't forget, sir, Martin Mehule was the speaker. Then shortly after that, the Rivers State House of Assembly complex had issues with fire outbreak and an explosion. And the House of Assembly, under Martin Mehule, suspended Edison Ehe and 3 others because of that issue. There were allegations and there were litigations in court that they are still answering to. And while suspended, these individuals, these lawmakers, went to court to get an order recognizing Edison Ehe as the speaker. Are you aware of that, sir?
Can I tell you?
So now,
I laid the foundation. I wouldn't get into. I said I will not get into those. Can I make a difference?
It's also important.
No. I said here I'm a lawyer. No, hold on. Another person can discuss that, not me. You know why? I said, no, listen now, I want to tell you. I said here that once a matter is sub judice, I laid that foundation, that I will not discuss in that matter to the merit, or that's what you're pulling me to. As a lawyer, but I am discussing the provisions of the Constitution.
But the reality in Rivers State,
it exists.
Is that the legality.
If I am not occupying the position I occupy, I would have discussed
the legality of
Lorisha, understand one point.
It's being questioned because they are suspended lawmakers from the House.
Understand one point.
But you're recognizing them and speaking that they are the Rivers State House of Assembly.
See, listen, I will not mention any person's name in my analysis. I mentioned the general situation, even if it happens in Cross River or it happens in... If you watch me, I've not mentioned their names. Okay. What I'm saying is that the position of our Constitution, as a constitutional lawyer, even if I'm a lawyer representing any of the parties in the court, I can still discuss on the basis of the Constitution. But where you're dragging me to as a lawyer in one of the matters, I can't go there.
On the basis of the Constitution.
Yes.
Let me ask you, Henry.
Yes.
On the basis of the Constitution. On the basis of the Constitution, does a suspended lawmaker have the right to be elected
this
as
I can answer. Now, let me tell you a circumstance where a suspended lawmaker can work for a house. I tell you, please listen.
Right.
Number one is...
To the Constitution.
Yes, to the Constitution.
All right.
Number one...
Which section, so we can bring it out?
The Constitution of the Federal Republic of Nigeria, Section 90, establishes a House of Assembly. Then, of course, Section 92 or 93, please help me. We talk about a speaker. We must have a speaker at all times.
93.
93, we must have a speaker at all times. Now, look at the situation where members of the Universal House of Assembly, or any House of Assembly, as a speaker...
There shall be a clerk.
No, then your 92 may be speaker.
92. 92 says there shall be a speaker.
Okay, so that's okay.
And a deputy speaker
of
a House of Assembly.
Of a House of Assembly, that's okay. Now, what happens with respect to suspension is an eternal issue. You don't have that in the Constitution. It is by the procedures of a House. Okay? And that is why it cannot override the Constitution. What the Constitution recognizes is any person elected into the Constitution, into the legislature, whether it's the House of Assembly. Listen, I'm not mentioning Rivers State House of Assembly because I don't want to be dragged into any matter that is sub judice. And maybe I'll tell you now, I am a lawyer in one of the matters so that you can understand how I'm constrained.
All right.
Good, but I can discuss the Constitution. Okay. So let me even take Jigawa so that I don't fall in the trap of discussing a matter that is sub judice. In Jigawa State, for instance, if you have a House of Assembly, okay, where the Constitution says they shall be 20 and not more than 40 in the minimum. Yes. The Constitution never envisaged a situation where any House of Assembly will deplete to even one person. But, Lorisha, I tell you as a constitutional scholar and a constitutional lawyer that a situation will arise at a House of Assembly membership may deplete even up to 2. And the question Nigerians have not been able to boldly answer, does that House of Assembly cease to exist? No. What happens is that there are 2 members. The 2 members will hold sway, will hold forth for the meantime for the House. But what would they do? They will notify INEC to say, look, we have depleted to a disturbing number. Please conduct election to fill those other vacant positions.
So they will conduct legislative activities.
Yes.
What does the
that's the Constitution.
What does the Constitution say about a quorum?
Oh, good.
You have all yours. Okay, you can.
Constitution said about a quorum with respect to members of the House. No, give him.
It's okay. Let me take it back at the chair.
What does the Constitution say about a quorum?
I'm coming. You see, because Henry and myself, we have been on this on opposing sides for some time now. If I'm mistaken, good.
Okay.
Now let me be very clear. You see, I'm very happy that he is holding tenaciously, to our 1999 Constitution. And on the same hand, he's saying, or he's suggesting, that those who feel that their rights have been infringed upon cannot approach the courts. Now, let me tell you.
No, I didn't say so. I said they are the ones that should even approach the court.
Good.
Exactly.
Okay, good. Now, let's even take it from this particular angle. Section 109 sub G is clear, like he said. He said the Speaker shall vacate the seats of those who defected from Party A to Party B. Then the Constitution under Section 109 sub G now flowed to a proviso that says, provided that the defecting members are able to prove with germane, cogent, and verifiable reasons.
Section 109.
Section 109 sub G, then they say proviso there, down, you can read it. there's a proviso that if these people are able to prove, you understand the point now, that they defected from party A to party B because of the division in their national body. You understand? It's not state. Division in the national body of PDP, APC, I'm sorry, I have to call it Labour Party. And that particular proviso, in my own legal opinion, has given a leeway, kind of, to whosoever that want to challenge the vacation of those seats to so do.
Correct.
The speaker has the right to do so under the constitution. But the person can challenge under that particular proviso, and which these particular 27 members have done. I don't want to dwell into the case in Abuja. That is why INEC has not been able to conduct elections on the so-called vacated seats, because the INEC and the Rivers State of Assembly was restrained by that particular order. I am not aware that INEC or the Speaker's House of Assembly, speakers or whatever, have gone in there to vacate that particular order, the restraining order. That order was given that INEC should hold on, cease fire. Then you now allow us to adjudicate upon this matter before we now reverse. And the court now said status quo ante bellum should be maintained. And based on that, that was why the 27 law makers were not sitting accordingly somewhere, somehow. Some people say it's illegal, but I don't want to go into that. 2, and because of that particular order that was given, you find out that the Ehie faction, after the Ehie faction, immediately they left his position as speaker to now become the chief of staff to the present governor. The other 3 or 4 members did not sit from that time, December 13 to just this month, when the governor had to do what? Had to appoint, they had to appoint another speaker for themselves. So for about 3, 4, 5 months, they did not sit until this particular issue that came up. So that is number 1. Number 2, I have asked my learned friend, let me not even personalize it. I've asked people to go and read, the Abegunde case. A lot of people make allusions, to that particular case. Yes, Abegunde, as it was a legislator, a federal legislator. So he left Labour Party also and defected to another political party. And when his seat was supposedly vacated, he ran to court and informed court that he has reasons why, he had to defect. The court listened to him and I gave an order, for that particular, order to be arrested first of all, pending when he would go. He was sitting in the House of Assembly based on that particular, court order. But when the matter now got from Federal High Court to Court of Appeal to Supreme Court now came and I said that Section 68, which is the one affecting, them, does not act in vacuum as it is. Yes, the Speaker has the right to vacate that particular seat. You also have the right to come to us in court to adjudicate. Okay, let us see your reasons. But the reasons proposed and put in his affidavit evidence, according to the court, said was not sufficient to sustain Section 68G of the 1999 Constitution. Therefore, he now had to vacate. It was after the court pronouncement that particular seat was now vacated and he left. But in this particular case, the Speaker, the Governor, or anybody at all does not have that imprimatur of authority to so vacate what the courts, the judicature, has not done. I reinforce my authority with the Joshua Dariye case. When you talk about 3 members sitting, 4 members sitting, of course they can sit. If there are 2 members, they can sit, as the case may be. In the Joshua Dariye case, Onoege said that the Constitution never contemplated a situation where the minority will not take over the majority, God forbid. That is the word he used. That in this case of an assembly, because the Plateau State issue is just like that of the River State, no matter as case may be. Some members vacated and defected to a different political party. You now had about 9 or there about 7 or whatever to now do the business of the day. Now the court now said, they now went out to impeach the Joshua Dari. Dari now approached the court to ask the court if that particular assembly of 9 or 7 members were properly constituted to impeach him. That was the kernel of the case before the Supreme Court. The Supreme Court now came and said, the assembly of the state consists of 24 members minimum, 40 members maximum. But where a situation arises, where the assembly is depleted, they can sit and hold their meetings. But whenever and whenever that functions and proceedings of the assembly requires 2/3, 1/3, that they cannot do that, they cannot sit on that particular matter because it requires 2/3, 1/3. For instance, to pass a budget, you need 2/3. For instance, to form a quorum, you need 1/3. That they cannot do that. That what will happen is that whoever the protest speaker is will adjourn until INEC conducts, the election to fill those vacant positions. So in this particular case, the 3-man or 4-man of assembly for me can sit and be doing their party, drinking their beer and drinking their tea. But whenever it comes to an issue where the legislature is supposed to put a seal of 2/3 majority of the House on a particular issue like appointment, budget, laws that is being passed TC, they don't have that right to function. No, they cannot seal it. They cannot put that function on it. And lastly, last time, I'm sorry I'm taking your... I
wanted to just quickly ask you a question based on what you have explained and said now.
Yes.
The action of the River State House of Assembly, the Oko-Jumbo faction of River State House of Assembly, confirming, inviting a senior advocate of Nigeria for confirmation, as commissioner, is it legal? Is it acceptable?
Well, I have not dwelled into the concern. No, whether I think a 1/3 or 2/3 is needed for confirmation of commissioners or public. I don't know.
You talk about appointments.
Yes, appointments. Yes. If it is 2/3 of the House that is needed, and they have gone ahead to say yes, they have confirmed, they have vested themselves to that particular power.
193.
Then it behoves.
192, 193.
It behoves that what they have done is an illegality. But if the Constitution says, a simple majority, then they can go ahead to do that. But if it is 1/3 or 2/3, I will find out later in the day, under the Constitution, whether it's 1/3 or 2/3, that they need for them to, confirm speakers. I'll come about. I know that if it is 2/3 or 1/3, they don't have that premature authority to carry out this particular appointment. Finally, all I wanted to say was this. Do you know what happened? Onwege made, an analogy which was very technical and sweet in my ears. He said it's just like a house that has a tenant. That by operation of law, that is the word he used, that their tenure expired and it became vacant by pronouncement of that particular speaker. But he now likened it to a tenant who is in a house owned by a landlord. That when your tenancy expires by way of operation of law, that does not mean that the landlord will come to your house and break into your house and throw your things out because your tenancy has expired by operation of law. You have to go to court, to get that consequential order to take them out. That is why he's encouraging everybody to do that instead of going into violence. I believe that with the matters in Abuja, these people, 27 members, they still have that right to sit on their own. They have the right to sit. The court gave them the premature authority to sit. The second one is this. The Constitution never contemplates a situation where minority will rule over, majority. Finally, on this matter, to tell you that the Constitution even envisage a situation like this, the Constitution knows that a situation like this may arise one day. That was why the Constitution, under Section 11, Sub 4, put it very succinctly clear. I can read it to you people here. That when the House of Assembly of any state is unable to conduct its business of the day by virtue of the fact that they are not able to form a quorum or whatever the case may be, that the House of Reps should take over the legislative function for that house but cannot impeach the governor. The House of Reps should take over the legislative function of that house. In 2013, this was invoked when Musa was the House of Reps member that gave a motion in the House of Reps from Taraba, where the crisis in Rivers State between Mbu and Mechi TCS was ongoing, that they should take over the legislative function of the Rivers State House of Assembly. So section 11 sub 4 has captured this. So people say the constitution never envisages. I disagree. The constitution envisages a situation where the house cannot do its business practically. That is why section 11 sub 4 was now enacted into the law to cure that mischief that they are trying to perpetuate right now. That is my take on this particular one for now.
All right. Now, back to you, Henry.
On this matter?
I wanted to ask you clear questions. Now, in your opinion, the action by the Okojombo-led House of Assembly, inviting a senior advocate of Nigeria for screening for appointment as commissioner, is it acceptable?
Yes, it is.
Legal?
Yes, it is. It's legal. It's constitutional within their power.
How so?
I should explain?
Yes, please.
Okay, thank you.
Explain, because
let me start. Not to worry,
yeah,
not to worry. Right. Section 192 of the Constitution of the Federal Republic of Nigeria vests the absolute power, absolutely, on the governor to form his cabinet by appointment of commissioners. In fact, to the number, it's the discretion of the governor. Who it should be is the discretion of the governor. It is in that process and that procedure that you would have the nomination of commissioner designate by a governor, and he shall submit to a House of Assembly, to the Rivers State House of Assembly, Bayelsa State House of Assembly, Akwa Ibom State House of Assembly. Now, the only persons that are entitled by the Constitution to sit in the House of Assembly for legislative business or any of the functions of the legislature are people elected to that house. Okay. And as far as we are concerned, I am not sure that anybody would even say that those gentlemen who sat as members of the Rivers State House of Assembly have ceased to be members of the Rivers State House of Assembly. There is no such thing as suspension in the Constitution of the Federal Republic of Nigeria for any person elected into a house. Anybody that challenges me on that should open it.
How come Senator Ningi was suspended?
There is no such thing in the Constitution. I have mentioned it earlier. I said within the Constitution allows any legislative house to formulate internal procedures. Now, in the internal procedures, you can make issues about discipline. And you know what, again? There is no procedure that will even be made by any legislative house. The courts have held that. My friend will confirm that you cannot suspend a member of the legislature for more than one sitting. So you don't even have this. These things are happening in this country. I'm sick and tired that people do things that don't find foundations in law. You cannot, in a legislature, suspend a member that was elected to represent the constituency for months or if indefinitely. It is not correct, but that's another business for another day.
Yes. You also,
so I think
also said
in my view that they are correct.
They are correct.
Yes, they are members of the Rivers Assembly.
Now, you spoke about the governor's executive powers to appoint anybody
to his cabinet.
Yes, that is not...
It's not in doubt.
Yes, that is not actually the topic. The question is the legality of this action. You said that...
I said it's okay, it's correct. Legal. Anybody who feels it's not can go to court and challenge it.
Because
they do, in my own view.
The Constitution...
I just want to add something, the trauma.
So that why not if she finishes with me? Why not if she finishes with me? You have your time.
I'm so sorry.
The Constitution...
Yes.
96, Article 96,
yes.
1,
yes.
said the quorum of a House of Assembly
shall be one-third
of all.
Of members.
No, not of members.
Of all. Now go on, I'm reading. I've read this several times. Okay, read it. Let me keep quiet.
The all that I'm
all what?
In. He said the quorum of the House of Assembly shall be one-third of all the members of the House.
Excellent.
In River State, how many members do we have?
You see, now you're dragging me further. Because and I don't want to say it is not my business.
Are you now saying?
Okay, do you want to say? I will say it. For me,
the Constitution,
okay, let me answer you so that you'll be satisfied.
Legislate.
Yes. Yes.
Can legislate.
Anybody, I can be wrong, but that's my view.
Against the Constitution.
Yes.
Of one third.
Yes.
Being the quorum.
Yes.
Unconstitutional.
One third of what?
Legislation. Of
Laurentia, who are the members? That's what you should ask me. My own members of Rivers State House of Assembly, I don't want to go there. I told you that there are matters that are subject. I'm even a lawyer in one of the matters. Ask my colleague. I will concede to whatever view he has. But for now, I wouldn't. Okay, you know what? Let me dare it. Maybe I wait for the body of benchers to take my license. But let me tell you, so that you get satisfied. I don't know whether you ask me again. And can you give me a minute without even a response? And I'll be done in 1 minute. It's my view you ask, right?
Yes.
You're not asking about that person's view.
No,
in my view, you see that section you read with respect to quorum?
Yes.
Of all members, then the question you ask, who are the members? In my response, the members of the Rivers State House of Assembly at the moment are 3 of them. So if you want to determine 1/3 of 3, then you ask me. But if you remain in the position that you think that 1/3 of Rivers State House of Assembly today is 30 or 31, then you have a different view from me.
All right, let's go.
So
back.
my view, there are 3. Okay. So it can 3 have 1/3? Yes.
Let's quickly go back.
So you can go back to any person.
Before you ask, Barrister, you still have your say. Let's go back to Article 91. He said, subject to the provisions of this Constitution, a House of Assembly of a state shall consist of 3 or 4 times the number of seats which that state has in the House of Representatives, divided in a way to reflect, as far as possible, nearly equal population. Now, my question lies here. Provided that a House of Assembly shall consist of not less than 24 and not more than 40 members.
Can I explain?
Which was the minimum?
Let me explain. This is constitutional law. It's not media.
Well,
can I explain?
It's the Constitution.
Good. I have read it. I'm a constitutional lawyer with all pride.
All right.
I have a master's degree in international and constitution.
Yes.
Can I explain?
As against the 24.
It is not what it means. Listen to me, please. Do you know what that means? In delineating, in the beginning, if you form a new state in Nigeria today, for INEC has the responsibility to delineate constituencies for a House of Assembly. Now, in creating any House of Assembly, you shall not have less than 24 seats and not more than 4. Listen, please.
All right.
I'm not talking about members at it. This situation in Rivers State was never a situation anybody intended. I am talking about the number of seats in Rivers State House of Assembly remains 32. But they are vacant. Isn't there a difference?
By who? Is the matter
You're asking me again?
Is the matter in court?
You're asking me again?
When you said it is vacant, the matter is in court.
I have told you here that it is not the court that is required to declare vacancy. It is not. Do you know what? Like, he agreed with me. Do you know what he said? He said, when this situation arises, when members defect from a legislative house, the first thing to be done is not the court. It is the speaker. If the speaker is not one of those that left, the one of the cases he probably referred to.
And you remember I asked you who declared was a suspended member.
It was a speaker at the time.
You said you will not look into that.
I said so. You were dragging me.
It's the internal affair of the party.
No. I said it's sub-judice, and I know of those cases.
And you also said that also the Constitution also allows the legislature, the State House of Assembly, to also have their internal.
Yes. And then they elected their speaker.
And they had their internal proceedings and suspended this.
Where am I? Which one am I answering?
No more constitution.
Lorisha, which one am I answering?
This whole thing is a conundrum. And you know, you keep...
Anyway, you can disagree with my views.
The Constitution is subject to interpretation.
But let's say one thing here. With respect to everybody that has interpreted the Constitution, the Constitution has one way to interpret it. But you know what? We can choose by whatever influence to go different ways. And for me, knowing that, I'm not surprised at all. Even if I sit here and any person disagrees with my view, I relax. It's the person's view. I hold my view tenaciously. And my view is that even the question with respect to Section 91 that you have asked in terms of quorum, Rivers State House of Assembly has a 32 constituencies. That does not mean that at all times there will be 32 members. There's a difference between the constituencies and the members. At the time, you have a 32, okay, let's say you have a classroom of 32 students. And the school says no class should be less than 32. You have a classroom of 32. Unfortunately, by accident, it happened to Loyola Jesuits. And then they went to, probably they are going on excursion, and 30 die. One person. Is that one person not a member of the class? As the class ceased to exist, that one person is the only member of the class. If they say, hold on, if they say people of primary one come out, if they say people of primary one, and it was primary one, people of primary one come out, they were supposed to be 32, but unfortunately it's one person remaining. We did not come out as primary one person.
Let me ask you.
And take the gift for primary one and keep first until they get new students employed to that place. What is wrong with us?
Who is the deputy speaker of Okojombo?
There is a deputy speaker. I don't know his name.
What's his name?
I don't know his name. I am not a member. No, he does have. No, he has.
All right.
You see, you are in the media, but he's reported. He has a speaker, he has a deputy speaker, and the leader.
I don't know, because
but anyway, before I still come back to you.
Right now, this matter, I don't know. I thought we had to have a
I used to have my phone here. I will find out the name of the
dialogue and maybe a trialogue, as case may be.
Yes.
You know, right now, let me take a bite at the cherry or apple, as the case may be. You see, when people talk about constitution, the constitution is not a placid document. The constitution of Nigeria is the ground norm and is the fourth earth origo. That is the source and origin of whatever we are talking about here today. That same constitution has given the courts the powers to interpret the constitution itself. That is why you find that under section 46 of 1 of the 1999 constitution, every Nigerian citizen has the right to approach any court of law that is well constituted in Nigeria to do what? To remedy breaches of his fundamental human rights. 27 lawmakers might come under that plank. They can also come under deny unfair hearing, as the case may be.
That's not correct.
That is 2. Is that whether the House of Assembly that has suspended 1 or 2 members, whether they have the right to do the suspension, they do have that right. Internally, by their internal memo organs and procedural rules in the House, they have the right to suspend, their members. And with that member forcefully return back to that particular house and begin to sit amongst those who suspended them without the caveat being lifted, for me, that is an illegality of the highest order. But I cannot interpret or I cannot say much about that because it is their own business. Under the law, also the Constitution, when a decision of that matter is taken, there's what we call an ouster of court. Out of it, section 100 sub 11 or thereabout. 2 is that in a house that is supposed to be 32 members, I have to reiterate this again, that has to be, it's made up of 32 members. By accident or coincidence, 29 members are absent. And you say 2 or 3 members can go ahead and vest themselves with that imprimatur of authority to carry on proceedings, make laws, appoint, etc., and give it that baptismal right to do what 2/3 should be done, 1/3 should be done. I disagree with that. And the Supreme Court has stated, when they were trying to interpret section 102C, where most of those on the other side are relying on, that the House can operate, even though there are vacancies in that particular body. The Supreme Court, again, in that same Joshua General case, said that, of course, this particular 102 is a general provision of the Constitution. That where the general provision, contests or clashes with a specific provision of the Constitution, that the specific provision takes precedence. And it now went further to that say, and dumbrate by saying that when 2/3 is needed to do what? To remove the governor, 2/3 must be gotten. And 2/3 of all members, not those members present, like it happened in that particular case he was dealing with. 2/3 of all members. That where that business cannot be transacted because of low blood count, because that was low blood count, that the assembly cannot vivaciously function very well. That the assembly, has to keep adjourning, and INEC has to fill up those seats, before they can go ahead to sit. But if 2 or 3 are sitting, they can be coming to the assembly as members, but they cannot take some certain decisions, like the budget that was passed by the group of 5. That is, it needs 2/3 of members of the House. A situation of that nature, where everybody and the assembly is depleted to that particular level of 15% blood count level, what ought to have been done under the Constitution, or what should be done, is that section 11 sub 4 should operate right now in Rivers State. And it's just a single motion, like it happened in 2013, when the House of Reps by motion, moved by a member, unanimously agreed and decided that henceforth, if the Rivers House of Assembly could not function very well, that they will begin to make laws for the House of Assembly in place of the local House of Assembly under Section 11 sub 4. That is what should happen to stem this tide of illegality so that they can go and settle their court cases in court. Because this one is talking, I am the speaker, this one is saying, I am not the speaker. What should happen is that let that particular Section 11 sub 4 be invoked by members of the House of Reps. Ugochi, if you listen to me, I am speaking to you directly, sir. You are a member of the House of Reps. The Rivers State House of Assembly is dismembered, is in tatters, is in comatose, is in ICT unit of the hospital. The blood level, the PCV level of Rivers State House of Assembly, instead of 32, is 3. It's an aberration. You have the right to save democracy in Rivers State, not by going on television. Invoke Section 11 sub 4. The gentleman that moved that motion 2013 was not a member of Rivers State, he was from Taraba. I don't know if you are from Rivers State or from Imo State. You have that right to move the House of Reps you belong, to invoke Section 11 sub 4, to take over the functions of the Rivers House of Assembly so that you begin to make laws for them. Under Section 11 sub 4, he said they can make all laws except they cannot impeach the president, the governor of the state. So what are you waiting for? Because this matter has eaten deep into the fabrics of democracy in Rivers State. Right. Lawyers are divided. Lawyers have divided opinion. Even yesterday, I listened to Falana. Let me just encapsulate and end this here. I listened to Femi Falana, a man that has so much respect on one of the TV stations. He said yes, that the Rivers House of Assembly members, 27 that left, by virtue of the pronouncement of the speaker, that they lost their seat. But he said, but a big but. He said, but a big but. That they can approach the court like they have done. That they can approach the court like they have done to vacate that particular order. Once they're able to arrest that particular order, they can sit down there and do whatever they want to do, pending when that particular decision returns, like in their Begude case. That is what I am trying to say here, that if an order has been given to them, 27 to sit, then, and the order has not been vacated, that particular order given to the 7 members, people said that the governor should not tamper with their allowances, emoluments, etc., as the case may be. It's a standing order. An order of court that was given is subsisting. And by virtue of Section 287, we are bound to obey and execute an order of court, as well as it is well constituted. But democracy in Nigeria, like I said, is a voodoo-type democracy, like what's happening in Rivers State now. So it is executive, having a legislative arm attached to a suitcase now. What are we looking at is tyranny, anomy, and anarchy. Right. I'm praying that this do not before Rivers State, a state that is well loved by all of us.
Barrister Sims, one quick question before we move on to the next story. Now, that is on the issue of suspension. I'm actually very interested in the issue of suspension. It's an internal procedure, like Henry has said. Now, when you look at the Okojombo faction of the Rivers State House of Assembly, it says clearly the updated House of Assembly information on the website for us to see. The Speaker of the Rivers State House of Assembly currently is Victor Okojombo. And then the Deputy
Factional
Speaker, the Factional Speaker, of course, is Right Honorable Victor Okojombo, yes, PDP. Then the Deputy Speaker of the Rivers State House of Assembly is Honorable Sokari Goodboy, okay, PDP. Now the leader...
Deputy Speaker.
Yes, Deputy, that's the Deputy Speaker. Now the leader of the House of Assembly is Honorable Adolphus Orubiemiha, PDP.
Okay.
Now, the deputy leader, Honorable Linda Korama Somiari Stewart, yes, suspended APC. Chief Whip, Honorable Mwabochi Franklin Uchenna, suspended APC. Deputy Whip, Honorable Ofix Kabang Christopher, suspended APC. And now, This is actually updated. You can find it on Wikipedia, actually. Now, this is what has been updated. This is what is online for anybody
for the
who
River
cares.
State House of Assembly.
Yes, for the River State House of Assembly, for anybody who cares to see. Now, with the question of suspension, you know, I raised concerns with Henry when I asked him that prior to Edis Nehie's emergence as the House of Assembly, Factional House of Assembly Speaker, he was suspended by the Martina Mehule, as well as three others by the Martina Mehule-led House of Assembly. And how then isn't it illegal for a suspended member to be appointed by fellow suspended members and then take over leadership of the House of Assembly? That's on one hand. He said it is not constitutional, so he cannot speak on it. It is an internal procedure and shouldn't hold water where the Constitution is granted. Now, this has been updated, and to all that cares to know, the question now is, within these people that says they are within the Okojombo faction, we now have a speaker as elected, and we now have a deputy speaker as elected, Sokari Goodboy. And interestingly, the leader of the House, the deputy leader, the chief whip, they are now writing suspended. How did they come about, these people? How were they voted in when they were suspended? I want clarifications. How were they voted in as leader of the House, deputy leader of the House, chief whip, while they are suspended and they were not part of this particular plenary? I want to understand. And if Henry says when they are suspended, then you know, it shouldn't hold water and all of that. And
I didn't say
when it is internal proceeding.
No, I said it is internal procedure, not constitutional.
Let me just help you.
How come the River State House of Assembly, this is updated and these people are recognized as suspended?
See,
I've explained to you, but you wouldn't want to take it, so take his own. When you're done with it.
I'm frankly, to know.
Larisha, like I have explained, when you keep on talking about this suspension, sorry please, just a second.
Because that's part of the
I have
issue
told you.
River State House of Assembly, that's part of the crisis.
Larisha, there is a point you are missing.
What's the point?
I told you. Let me make an illustration. Okay. You have 5 students in a school, 5 students in a school, and then 3 of them were rusticated, expelled. They are no longer members of the school. 2 of them were suspended. Let me even say that the 2 that were suspended before the rustication, who are still the members of that school?
How did the suspended or the rusticated people,
could you please
how did they appear as
no, listen, let's take it one step and another. That's what I'm asking. Now, okay, you don't want to answer, I will answer it. You have 5 students in my school. Let's say 2 were first suspended. They remain students of the school, maybe suspended for 1 month or suspended indefinitely. Then that school, 3 of them, let's say, die or become rusticated or expelled. The question is, who are the remaining students of that school? I'm not talking about whether they are suspended or not. It will be those 2 that were suspended, right? Good. Then now I will now say, okay, hey, community secondary school, Kala Ogbogolo, where we are doing a parade. Please, those who are students of that school, those 2 members, that their suspension has become a matter of necessity. They would come back as the only students of that school. Their names are still on the record of the school. The other 3, their names will be wiped off of the school.
Their names are not wiped off from
no, listen, I'm talking about expulsion. Hold on. You're getting it wrong, please, with respect. It doesn't align. I am coming to it.
Okay.
No, I think I'm becoming more interested. I never wanted to be this passionate, but you're getting me into it. And I'll be passionate here now. Now, let's say the 3 of that school were wiped off. They will never come back. They are not members. The other 2 who were suspended remain members. You and I have agreed to that. Whether you do agree or not, the fact is that they are members of the school. They were merely suspended. Now, when it comes to the business of that school, hey, we are doing a march past. Community secondary school, you are still a school recorded in this local government area. The 2 members will come out to do the march. That is how, when the circumstance in the River State House of Assembly got to the point that 27 of them, as far as, I'm not saying to Martin Amehule, they will continue, like him too, they continue to say they are the members. But understand now that you have a divide. That those who were saying that Martin Amehule and his friends were no longer members of the House of Assembly. That is how these gentlemen who said they are the members of the House of Assembly, howbeit you were saying that Martin Amehule suspended them earlier. I'm telling you how, assuming without considering that the suspension was even valid, that is how they remain the only living or surviving members of the House of Assembly. Liking the expulsion or vacation of office as deaths. If you have vacated the office, it remains an argument that even the SAN Falana, who is the chairman board of trustees of my organization, has spoken to that clearly. He never was able to say strongly that that's what Falana said in the interview with channels.
That
These are those people have vacated their seats.
Falana is not the judiciary.
No. That's the course has said so.
Falana can only give his opinion.
Oh, now you say so.
No.
Good.
Falana can only give his
excellent. His opinion. But can I tell you that Supreme Court?
His opinion.
Hold on now.
His opinion is not the. It's not
okay,
the Falana.
Lorenza, the Supreme Court of the Federal Republic of Nigeria, the Supreme Court of Nigeria, he knows. The Supreme Court has said. No, I want to tell you now. Okay, it doesn't matter you have analyzed here. He has another table here.
I don't know that one.
Okay, not to worry, you don't know. The Supreme Court of the Federal Republic of Nigeria has said that any person who vacates or who moves from his political party to another political party without justification has lost his seat. And you know what? I don't want to say deep. That division you're talking about, the regime stops the proviso. It has been explained by the Supreme Court.
Granted, now let the Supreme Court
you cannot explain again.
I just want to say something, please. I just want to say one or two things. See,
you know what, Larisha, I'm not going to say a word again on this matter.
The argument or discourse, I don't.
But you know you have talked more than I have done.
I know I've not spoken more than you've done. It's only like that.
Go now, take your matter. Please. You and I don't have any issues. Have your view. Submit your views, and I won't say anything again. But you know what? Hold on. This is my last word. Any legislator in this country, if you like, we should joke with our constitution, and I would not. Any legislator that defects from the political party that sponsored him to another, without the justification as explained by the Supreme Court, whether we keep him, whether we keep that person, whether we go back and forth and behave the way we naturally will behave, that person has lost his seat. Right. The person may still remain there. It's their business. I'm not a politician. I'm done with this discussion.
Yes, no problem. Lorenzo, I think what I just need to do, because I don't know, I don't have anything with, I'm not here to convince anybody to believe in my opinion. It's my opinion, and I stand by the opinion that the 4 members of assembly, concocted recently is an illegality. It's an illegal contraption. I remain so, and I'll follow it till I'm challenged properly anywhere. Now, let me tell you why. The question I want to ask people is this. Why did they elect a deputy speaker and speaker? Is it not in conformity with the Constitution? The only two positions recognized by the Constitution in the House of, 3 of them. The 3 positions recognized in the House of Assembly of of all the states in Nigeria are number 1, the clerk of the House. The clerk of the House. There's a modus on which the clerk can be selected. Let me use the word. After the clerk of the House, you now have the position of the speaker. After the speaker, you have the position of the deputy. And these 2 positions that they are pretending to hold here, it says that 2/3 of members, the recognized House of Assembly of Rivers State is that of the one that was founded or that was inaugurated by Martin Amehule, where all the members of, or maybe about 2/3 of the members of the House voted and made Martin Amehule the Speaker of the House. He was removed by gunboat diplomacy. He was taken out, by a forum-shopped, something that we all know. And that contraption immediately was given. They ran immediately to go and do what? Usurp powers and at the same time baptize the budget of Rivers State through the back door, what we call surreptitious, usurpation of power. And that has been the problem. That has been the foundation of the problem. And let me tell you, do you know that soon after that particular whatever was forum-shopped, that was when the man went and the assembly was destroyed. Democracy is in danger. But if you want to keep your eyes closed because of, affiliations, etc., without being objective, Nigerians, it's left to you. But this is what I've said. There is nowhere in the world that 3 or even 5 can legislate upon, no matter the logic that you bring into it. Because the Constitution, as interpreted by the Supreme Court, says that what the Constitution has specifically provided for must not be obliterated by a general provision. It says the House of Assembly of any assembly of Nigeria must not be less than 24 at a time or 40 at a time. And if they there's a dispute, there's a problem there are provisions to take care of this. And that provision is this. Assuming that considered that okay, 27 members, by virtue of their pronouncement by the speaker, have vacated their seat. I assume so. They have vacated their seat. Does that give him premature authority to fall, to now be to deliberate? And in the proceedings of the House of Assembly, when it comes to voting, the speaker does not vote. So he leaves them with just 2 members in the House of Assembly. So for instance, the commissioners brought before them today, the speaker does not raise up his hand to say, I vote, I or whatever. He only say the ayes have it. So if you subtract the position, the voting position of the speaker, of the 3, how many do you have? You have 2 people now. Making laws, and to make it an aberration, these same 2 people did not sit in a public square or anywhere. They were taken to the cocoons of government house. For me, you can go with your democracy the way you want to do it, but for me, it's an aberration. And the judiciary has kept mute where they ought to have made pronouncement. There are several litany convoys of cases before the High Court, both in Rivers State and Abuja. Why have none of them made a final decision on this particular matter? Why giving ex parte orders and giving interim orders? Whereas a matter that is constitutional, as we have seen clearly under the Constitution, if you want to do justice and believe in democracy, you act on this. These are matters you don't even need to call parties to come and begin to contest in court. It's affidavit evidence and applying the available law here. Why can't the High Court in Rivers State, for instance, rule and say, 27, you are not supposed to be there. 4, you are not supposed to be there. 27 will go back. Then they now go on appeal. And settle this matter quickly on appeal. It goes to Supreme Court. Abegunde's matter took 4 years. For those who don't know. The reason given by Abegunde is different from the reason given by the 27 here. A lot of people don't know that. He claimed that there is a division in the branch of Labour Party in Ondo State. And the Supreme Court said no, that if you say because there's a division in Ondo State, a branch of a political party, are you saying, with due respect, that if First Bank has a branch in Port Harcourt and the Port Harcourt branch is born, does that mean the First Bank cannot function? These are the things he said. But in this particular case, 27 members said that the national body had issues. A body that will listen to them is the court. Even though the speaker has made that pronouncement under the Constitution, yes. But they have gone to the court and court said, go back, status quo antebellum. Why are we not respecting those particular orders? Why this line, orders here and there? These are my take on this, please. Let me not eat up the time.
All right.
Thank you.